So Dylan, welcome.
Thank you.
This is your first time in the basement.
It is. Mm-hmm. It is.
Welcome to Boxes and Basement.
Thank you.
So tell us
we
a little bit.
We have a gold phone back there in case you have an emergency.
Okay.
It's a hotline.
Yes.
Tell us a little bit about yourself. You're a criminal defense lawyer. We've done a jury trial together, but we're here because of a very serious topic, and we're going to talk about trauma related to being charged with sexual assault charges. We can expand that a little bit more, but the real trauma about it. But tell us a little bit about yourself and your practice. And
well, I'm a criminal defense lawyer like you. I do lots of sexual assault cases. I do other stuff too. I don't know if it's as much of a focus. I do a lot of charter stuff as well, impaired driving. So a broad array of cases I take. But yeah.
But you've had quite a few sexual assault cases.
Yes, yeah. I have.
And you reached out because there was one in particular that, caused you serious pause, especially about, the things we deal with in investigations and the prosecution, and it's been a pretty tragic experience.
Absolutely. And your audience may know this already, but I just, there's a general public perception, I think, that if someone's charged with sexual assault, there must be a reason why, right? And, there are probably...
Where there's smoke, there's fires, the general thought.
Exactly. And so, there must be a predator, there must be something that's happening, right? And they think that because they believe the police investigation to be sort of uncovering every aspect and going through everything, and only when all the pieces fall in place is a charge laid, right? And so the story I wanted to bring, I wanted to pull the veil back a little bit on what sort of allegations can lead to charges, and then tragically what sort of consequences they can have on people. So, well, the story started, it was a particular, a girlfriend-boyfriend relationship.
How long were they together?
A few years or something.
So it was a serious relationship.
Yeah, totally. Yeah. And they broke up, and a few months after the breakup, the girl had made some allegations against him. And these allegations, there are some unusual facts about them, but they weren't outside of the pale, I think, that would cause me to pause as much. But what happened is she went to the police, and then months later, she went to the police a second time. And this time, her allegations were years earlier, he had drugged me. And while I was unconscious being drugged, or after being drugged, that's when he sexually assaulted me. And I didn't report this earlier when I had the opportunity to, because I didn't remember at the time.
You're going to love this.
Yeah.
Yeah.
And it's through... through my process...
In a very negative way. Yeah. Slow down on this one, because this is a... Tell it slowly, because it's painful. Go ahead.
Through my process of therapy and journaling, these repressed memories have bubbled to the surface. And so now I know that this happened, that when I was unconscious, he sexually assaulted me. And it happened in this particular month-long, roughly, time frame in this particular year that was years earlier.
How long previously? Like more
Several
than 10?
years.
Okay.
Not more than 10.
And it had to bubble to the surface.
Yeah.
Through some sort of undescribed process.
Right.
Journaling and therapy.
Which,
that's right.
As a lawyer, are you allowed to explore how this bubbled to the surface?
Well, yeah, in theory, we could. Any event, even more than that, my client for this particular time period had an alibi. And of course, with alibi, there's special rules about that, have to provide that to the Crown Attorney. So,
what are those?
Tell us.
Well, there is a notice requirement. I'm not sure. I don't think the notice has to be any particular form or anything.
Correct.
But the idea is that it can't be sprung on the Crown Attorney because there has to be an opportunity to investigate it.
For the police to investigate.
Yeah, you just basically give a summary outline of what the anticipated alibi evidence is.
You're not allowed to just surprise the court with it.
No, it has to be provided ahead of time, so they have a meaningful opportunity to investigate it, and you give a summary.
Exactly. So we did that.
And if you don't give them advance notice, what's the result?
Well, it could not be relied on, but probably an adjournment, I think, to allow investigation.
It can work against the interest of your client if they don't disclose it in advance.
It's bad. Yeah, either it can result in an adjournment, or if somehow it happens during trial, it can be given no weight, or you can even, in some cases, draw a negative inference.
That's what I was thinking. Yeah.
Yeah. And sometimes the fear of an alibi is if they do investigate it and it doesn't seem to hold water, then you can be in more trouble. But leaving that aside.
This is kind of important, though, because a lot of people who are charged with things think they can hold everything back and just surprise the court and just come out with some sort of huzzah, you know?
No, that's a good point, because people have actually said to us, like, months later, oh, by the way, and it's like, you know, it's very important to tell your lawyer ahead of time everything. But anyway, so you had this alibi.
Yes.
You gave notice.
Absolutely.
In your opinion, was it a good alibi?
It was rock solid. But the problem is because this allegation was from years ago, and she had sort of worked out in what month-long time frame it happened in, it's very easy to correct that, right? And so the Crown didn't even present it to her. They just said, well, it could have been some other time around then, and she was just mistaken, right?
Yeah, so that's the problem. You can keep moving the goalposts on the timing of the allegations.
This is something that I had a long time to learn, because I was just like, I thought that was true too. They give a time frame for an allegation. You think, huzzah? Again, I'm using that word. You know, but you just like, oh, I can prove I wasn't there. But they're actually allowed to change the time frame of the allegation because victims, they're called victims, presumed victims, are assumed to be, you know, having trauma. And so they may not remember things properly. So time frames are not, you know,
They're not carved in stone.
It's not a guarantee to win.
Unless somebody specifies a particular date, and it's not a question of a memory.
On an event.
If they give a time range, they can expand that. They can amend the information or the indictment at the end of their evidence.
Like if you say it was Halloween, I remember because I was dressed as, you know, Morticia.
Right. Yeah.
Right? Then they'd be like, okay, well, that's solid because I would dress as Morticia.
Right.
But, you know, but if you give some sort of a solid event, then you're more stuck with it. But if they just give a time frame, especially as you're talking about in a long-term relationship,
Right.
they can move that time frame. If you come up with an alibi, they can just say, oh, sorry, I got it wrong. It must have been this year instead.
Right. Yeah. So in any event, the goalposts were moved. And unfortunately, through the police investigation of this alibi, they contacted his workplace because the alibi had to do with a work timing issue. And because his workplace became aware of this investigation, there was some question about his work and whether he was continuing to work with them. And then my client committed suicide. So that was very tragic and a sad outcome. So we never got to see the case to trial. But the overall point I wanted to make is just there is a number of factors in this case, I think an overwhelming number, that really this case I don't think should have passed.
And I just want to say one thing important. So just for everybody who understands, in this case, the employer and whoever was at employment became aware because the police were investigating an alibi. But in many cases as well, the employer becomes aware through other means.
Sure.
And sometimes that can be the complainant communicating with an employer, and it can be through other means, through the police, for whatever reason. And people often, when they come to us, if they're in particular positions, wind up being suspended. So to talk about a life-changing event, your ability to earn a living gets immediately impacted. Right. And that was like a particular blow to him psychologically that was...
Yes.
Can I just mention something about my experience with people committing suicide in my advocacy for falsely accused people? Yeah. There was a really devastating circumstance in Vancouver where somebody committed suicide in the midst of the Me Too movement. And there was a list posted online with a bunch of people's names. Then they found out one of the people committed suicide, and online people went, yay.
Yeah.
Another dead rapist. They assumed that somebody would not commit suicide unless they were a rapist.
Right.
And then another person was not heard from for a long time, and they said, I hope he killed himself too. Yeah. And there's something to be said about that, because we should never, as a society, hope for somebody to kill themselves, ever, under any circumstance.
Well, we can hope for a lot of decency in our society. I've kind of given up on that, but because social media, everything's very bad. But yeah, I mean, I remember that, and people's names get published, and bad things happen to them, and it's who cares?
There is a shallowness, though, to think that that's indicative of his guilt, though. I would agree. Yeah.
Absolutely,
Exactly.
yeah.
And that's what I want to talk about too, because there's a presumption that if somebody kills themselves, they must be guilty.
Right.
And the reality is that people kill themselves when they're innocent.
Yeah, it could be both or either. Yeah.
It's sheer desperation.
Yeah.
I mean, that's what we've communicated many times, and people who watch this regularly do communicate it with, because they've come through years of difficult situations. Even if they're exonerated at the end of the day, it is life altering, and you
Right.
can imagine if you lose your employment, your surrounding support system could doubt who you are.
Right.
A marriage could break up as a result of it. Your life can and will be destroyed. And even if at the end of the day you're found not guilty, you're still kind of fucked, because on the computer system, all it will say is dismissed.
Right.
And that'll still be there for searches. It's life altering. So talk about more of the circumstances, because it's pretty sad.
Absolutely. Well, like I was saying, I just think the number of factors in this case should not have passed the smell test. I personally think. And when the Crown looks at cases to continue with the prosecution, they're of course supposed to look at reasonable likelihood of conviction, right, and public interest in the prosecution. Now,
This is called the duty of the prosecutor, where they have to decide how to spend their public resources.
exactly.
And they have to assess the, like you said, reasonable prospect of conviction. And that means looking at the case seriously to see what are the chances that this is going to be successful in court is a very important duty of the
Absolutely.
prosecutor.
Crown attorneys have a judicious obligation. There are many judges in a certain way, so they have to do that independent analysis to a very strict rigor. Didn't impress you on this one, I'd say.
Well, to me, there was a number of factors, right? Yeah. The dated nature of the allegations themselves, that they occurred during a period of time that she was unconscious due to drugs. To me, I'm not a forensic toxicologist, but I think that to be unlikely.
Did they call one?
They did not. We may have had it proceeded to trial. The fact that there's no external corroboration. Now, external corroboration is not required, right? But
For a good reason.
Yeah. Historical allegations, though, where there's nothing else, sometimes that can be
Helpful.
helpful, right? Then on top of that as well, the fact that there was no report to the police mere months earlier, even though that this is years earlier in time, right? And then finally, the nail in the coffin, the alibi, right? I think there's enough here to raise the reasonable prospect of conviction to say there was none. And maybe had the case proceeded, eventually would have got there, but unfortunately didn't. So,
well, let's talk for a moment,
Yeah.
because we've done several episodes and we've had two extremely notable experts on memory on. Mm-hmm. So Elizabeth Loftus and Dr. Patrice from the UK, and we had somebody else on, I believe. Patias, sorry, but we had somebody else on, I think. But memory is something that disturbs us, and it's made a comeback.
right.
Well,
So repressed and recovered memory.
People's ideas about memory and how strong that memory is, especially over the passage of time, and how people go about recovering memories. And there's still some people out there promoting recovered memories.
Right.
Which is,
Still, it's literally
Yeah,
made a
still.
comeback.
Mm-hmm.
You knew the case, we don't. Okay, so we didn't read it, but based upon the information that you were, I don't know, were you given therapy records of any kind?
No.
You hadn't gotten to that stage. Okay. And sometimes we don't even bother getting into the therapy records.
There's questionable whether we could have got them too.
Right.
Right.
I think it's important to say, though, at this point, because you bring up the therapy records, it's important for people to know that you can't just go into court claiming somebody's crazy.
Right.
Yeah, and this isn't crazy. So this allegation hinges upon a recovered memory through a therapeutic process. So we could apply under the criminal code to get access to therapeutic records. We have to establish that it would be relevant. There could be an argument here simply because of how it's hinged on that therapeutic process. But even if you're successful enough to get records and they would be vetted by a court, it will not yield much. Other than what I think would be important is the methodology used by the particular therapist. That can be of benefit. But it's not dispositive in any way. what I find much more concerning is that anybody really relies on this type of evidence sufficient for a basis to go forward with an allegation.
Right. Without some sort of external corroboration, perhaps, or something else, right?
Because there is an absence of memory from the get-go. It's like, I never remembered this.
Right.
Because I had a drug inducement issue then. I don't remember anything until I was in therapy many years later. And then through journaling and some hocus pocus, this came out. This is inherently fraught with unreliability and wrongful conviction written all over it. So I'm not trying to put you in a bind, because I'm more brazen to say maybe than you are. But I find this to be extremely, extremely troubling.
Yes.
But I think, like, to take it back to one of your concerns too, is that in the meantime, while we deal with all of these technical issues, the client is going through their own psychological drama.
Yeah.
And sometimes we understand that they're in a very dark place, and sometimes we don't. Sometimes you just suddenly find out your client died, right?
Yeah. And in this case too, he was charged twice, right? And the first one I don't think was the same way outside of the pale. I mentioned that, but he was like, Dylan, can she just say anything? Like, could she have other recovered memories from other times within these last, many year long relationship? And I had to say, yeah, that could happen, right? The police believe this one is sufficiently enough to charge you, so there's nothing stopping further charges in the future. Yeah, it was troubling.
But, what I'm saying is that when you're trying to prepare your case, we're focused on technical things.
Right.
And so sometimes the client doesn't understand the technical aspects.
Right.
And they start to feel despair.
Yeah.
And we don't always know that. And so you ended up in the circumstance where your client ended up killing himself without knowing that he was at that precipice.
Yeah.
Yeah.
Like we've engaged
I guess is
we've
the word.
engaged experts, therapists, to work with our clients, because we're not sufficiently able to help them in that regard, because you can see how fragile they are. But sometimes you might not know it. They won't say it.
We had a client actually who I remember when we met with him, and I said to him, you have to go to therapy, not to recover from what you did, but because you're not safe to date anybody else. He was so abused, and he let himself be so abused by somebody, that I was like, you're not safe to actually date anybody again unless you go to therapy.
It went beyond that. He was almost catatonic in our office.
He was. Yeah.
Because of the allegations and what he had gone through. He was almost catatonic. It was one of the first times in my career where I said, dude, you're going to this guy.
Right.
Yeah.
But can you give us a little bit more information on the alibi? Because you seem, when you say rock solid, that combined with the memory bullshit in this case and that alibi really disturbed you. So without saying more, like, he was off in some other province doing work for a whole 2 weeks or something?
His workplace brought him to another location for weeks at a time. And so that was...
So the opportunity to have committed what she alleged during whatever this time frame was significantly limited.
Yes. Absolutely. Now, it is true that because they were dating for so long, it could have happened the month earlier, the month later, right? There's no way to tell, right? But in her statement to the police, she was very clear. It must have happened between this time and this time, because that she pieced it together.
So in her statement, she gave definitive time period.
Yes.
So, October 1st to October 30th, for example.
Right.
And you had alibi evidence to cover a portion of that?
The entire period. Right. But they had been dating for 3 years.
No, but then the Crown, and we're not blaming anybody necessarily, but the Crown said, okay, but regardless of what time period she gave, it could have been another time period just because of the nature of recovered memory?
That's right. Yeah.
So here's one of the things...
They know what I'm thinking.
Here's one of the things that concerns me. How does this get logged down in the media covering the outcomes of court? This gets logged down as a case that never got to be tried, and an injustice for the victim.
Right. Well, no media doesn't give a about this.
Yeah.
No, they do.
No, they'd never report on...
We had the whole unfounded
No,
thing.
but this poor gentleman who died, who committed suicide, there would never be reporting on this.
They count. No, they do. They count those, Joseph.
No,
go
they
back
count
and
them as
look
data.
at- they look at the numbers. They don't look at the cases and the facts of the case. They look at the numbers. And then they tell the public that there's an injustice in the system because your case, where a guy killed himself, even though he was likely to have been, not convicted, that gets counted as a failure of the justice system now.
Right, but what I'm saying just from a hypothetical standpoint, imagine if W5, or whatever is still in existence anymore for these investigative journalism pieces, takes a look at a case like this and says, well, here's a case where we have recovered memory, here's the allegations, and as a result of an investigation on a fairly compelling alibi, the gentleman commits suicide because of the trauma of all this. Can you imagine ever getting the interest of any media source to do that? No. So the data collectors who are keeping track of sex assault prosecutions will put this down as one that unfortunately never got to trial.
Right.
But what
And
I'm
they
saying
assume
is
he's guilty.
Right, but what I'm saying is the lack of public interest in the human story of the accused is what bothers me so much, and the lack of scrutiny as to the impact of what I consider to be junk science on recovered memory does such harm and will never get the scrutiny it deserves.
Let's talk for a moment about, the way that lawyers deal with this kind of event where your client commits suicide. And you and I have talked about this a little bit, the secondary trauma. People think lawyers are callous. They think that lawyers are all just about, rules and regulations and so on. But do you not get emotionally attached to your clients? And when a client kills themselves, does that affect you?
It does. Yeah, I spent a lot of time thinking about this case because there's just so many issues, and then, it's just done, and it's really, really tragic. I think we could have won this case, right? But we never got there, and he gave up, which it feels like a failing, but it's tragic. Yeah.
Well, I sent you that piece that was posted on LinkedIn, and
It was really well written.
yeah, and it was talking about secondary trauma and how some criminal lawyers, experience secondary trauma because they're taking on the pressures of their client, where their life is at risk.
Yeah.
And some, you can come through years where you have some cases which are particularly oppressive, and you don't recognize how your own mental health is suffering as a result of it. And when you lose a client, and I had a client who had all charges withdrawn against him in a really high conflict divorce, and we put in a lot of effort with multiple experts and an excellent head crown attorney in Newmarket who carefully reviewed everything and determined that there was no reasonable prospect of conviction, and it was likely that the complainant had inflicted an injury on my client. I became very friendly with the guy because we spent so much time together working on it. Suffered through the divorce process still more, and then one day jumped. And the family lawyer in that case I had worked with quite closely. He was a well-known doctor who was an extremely well-respected doctor, who was a geriatrician, very caring with his patients, and that can be a very difficult practice because a lot of the times you're dealing with people who are not well in many ways, including onset dementia and many other things. Just a lovely guy. And that case stuck with me for quite a while, particularly because he sent letters to everybody before he did it.
Wow.
And it's awful.
Yeah.
No, I think this is so important, though, for people to understand, because there is a misperception about lawyers where they think you're all just like business people in it for the money or whatever. And what we do is passionate. Mm. And, I think the way you've described your case...
Please don't ascribe a heart to me. Please,
But, no, what you're describing shows that you care. And that's important for people to know. That this is not just about money, and it's not just about words and twisting words and whatever. It's like, this is about people for us. Mm-hmm. And we care.
Yeah.
There is, I say criminal law is one of the most, interesting and rewarding areas of practice you can have, but it can also be crushing. And, you internalize it, but then it makes you stronger because you want to do better for your clients in the future, right?
Well, there's also the aspect too is that sometimes, we don't often, but sometimes you lose a case and the person's innocent.
Yeah.
And you have to know that this innocent person's gone to jail and there's nothing you can do about it.
Well, we're not saying we don't
our
lose,
appeals
but we work very hard on the cases, and we're lucky with the type of cases we have. But yeah, you got to work hard. It's tough. And did you have, like, you're not naming anybody, but did you have discussions with the Crown afterward, just out of curiosity?
No, I didn't. I did put some comments on the record that were probably more descriptive than I normally would when the charges were stayed. Yeah. But no, we didn't
Any
talk
type
after.
of emotive response from anybody? Zero.
Not really. No. Yeah. There's probably an email or something that said sorry to hear that, but nothing major, unfortunately.
Well, that's one of the burdens that you bear,
Because I know Crown attorneys who would respond to this in a very emotional, unhappy way that happened.
And to be fair, too, the Crown attorneys, they work in a big institution, in a system, right? And ones who may not have been around for a long time, they don't feel comfortable making big decisions. They run it up the flagpole, right? And there's a whole cultural, institutional culture, right? So I don't want to subscribe any bad behavior to a particular Crown attorney, but it's,
we're not saying that. It's
many
just,
of them are really fair.
Yeah.
No, many of them are very fair, but it'd be nice to cause pause.
Yes.
For a statement to say, this is extremely unfortunate. This is not something that we ever wanted from a prosecution. So, our condolences. This is terrible. But also maybe cause, a little bit of self-reflection and maybe a little bit of internal review to say, should we have taken the alibi a little bit more seriously? Should we scrutinize this type of evidence a little bit more carefully? And this is where I urge that when you're dealing with, I'm sure there are cases where there's a memory that you don't forget. You have a memory of something, but your facts aren't as clear.
Yeah.
And so, you'll be remembering things and you're trying to not deal with it. And I understand that. And you try and push it away. But this concept of, I never had a memory of it.
Yeah.
I never, because that was your situation.
Yeah. But
They were drugged at the time. And therefore, after the act or during the act, there's no memory.
Right.
It just came out.
right.
And we've talked about, which you may not have run across, there are therapeutic modalities where, in fact, the therapists themselves
Right.
are unfortunately influencing the patient to have memories that they did not otherwise have.
Right. Yeah. Yeah.
And we've had leading experts on the podcast talk to us about
Can I
this.
just
It's
say
not
something
a
about-
bullshit phenomenon.
My experience through my nonprofit, which is mostly helping people who've been wrongfully convicted,
Lighthouse.
the Lighthouse Project, that I've talked to a number of people who have talked about being suicidal, and I said to them, the way I see it is it's almost like an existential crisis, where all of a sudden overnight somebody can make an accusation and take over your identity and make a statement and then change who you are. And then now it's your job to prove who you are. And it's like your identity has been stolen. And I've had a number of people tell me that they were suicidal. In fact, somebody who's thankfully didn't follow through on it actually put together a suicide kit and had it there at the ready. Thankfully, he had children, so he decided that he wasn't going to do it. This is something that can easily happen to people. And it's not just because, somebody accused you of something that maybe you did or didn't do. It's because somebody stole your identity. And you get charged, and now you're in the process.
Right.
And there's years ahead of you before you can clear your name. And some people can't make it through that. And we need to understand that.
And it's, it's stealing your identity, and it's an attack on your character and integrity, which can be a very significant emotional and psychological blow to people.
Right.
Was there anything else about that case that stood out to you where you thought, like, this should have been pulled?
Well, there was the whole thought about the two allegations, and they happen to be in different jurisdictions. So personally, I would have liked to do a joinder application. Now, that's quite difficult for a defense to do. It's not common for defense to do. And I did some research, and anyways, that was still a work in progress. But
did you feel that the second one was a ploy to bolster the first?
no, but I feel like the fact that the second one was so outlandish, it would undermine the first.
As a layperson, I just wanted to slow you down to talk about what a joinder application is.
Right. So if there's two sets of allegations against one individual, or it could even, in theory, be against co-accused, but you can bring them together to be in one trial, right? Or if they're all in a single trial or single information right away, there can be a severance application, which is commonly what defense does, to separate them into two trials, right? So in this case, just because the nature of how the allegations that come through therapy, I wanted to apply that, what I thought may have undermined the veracity of those allegations, and apply that to the first allegation as well. And, if she can't be believed on the separate second allegation that was first in time, I think there should be a credibility and reliability analysis to everything, right? Now,
like a reverse similar act.
right,
In certain
exactly.
ways, yeah.
What's good
On
for
a
the
multi-count
goose?
indictment, yeah.
Well, what's good for goose is good for the gander, right?
Yeah.
So, now, when the Crown Attorney does assessments for severance and joinder applications, again, it's not about seeking a conviction, right? It's about the interests of justice, I think, more broadly, right?
Public resources. As well.
Right.
Okay.
So would it be better for the complainant to testify in one trial or two trials, right? And would there be any other witnesses are disadvantaged, or what sort of inferences could be made because of similar fact evidence? That's one of the assessment reasons, right?
That gets complicated.
Yeah, but this would be one of those cases where you could, and if you run it, and we're in Ontario, so there's no harm in running it. Ideal cases where you have one offense in a different jurisdiction, it's still being litigated in another jurisdiction.
Right. I proposed this to the Crown, and I was trying to take the stance like, look, I'm trying to save resources. Everyone can be happier here. She only has to testify one time. That would be nice, right? There was no bite on trying to join them.
Were you going to do this case in the Superior Court, or were you going to do this in the Provincial Court?
I think I would have had to do it in Superior Court because, well, first of all, I think a jury would have been better for...
That's what I was thinking.
Yes.
So what's the consequence here? Just talking about his suicidal tendencies and stuff. Now he's not facing just one trial. He has to face two.
Right.
And so that's like extra resources, extra time.
Yep.
It's much more stressful for the person being accused.
Absolutely.
Although sometimes it's helpful to separate the cases, this can actually be a factor that, and I've helped people before too through Lighthouse that they got charged and then the person went back and made another statement with historic allegations, so they had to go to two trials. That's a lot of time and money and stress, where you're not just facing one trial, you're facing two now.
I did try to frame it to him. I said, the first allegation, we can win, right? But it's not, to me, there's not as much to undermine the veracity of the first allegation. So I was trying to be positive with him to say, like, this is a gift. If we can use this second allegation, it's actually could be helpful for us. Anyways.
And I was thinking definitely a jury trial on this one would have been interesting.
Yes, absolutely. So, but I think also for the defense to join it, from what I understood, there was no authority to do that under the criminal code. And so you'd have had to do some sort of application to the Superior Court because they have their own...
inherent jurisdiction.
Exactly, that's the word I'm looking for. Yeah, so...
you'd have to do in Superior Court and rely on inherent jurisdiction because you'd say there's commonality here and you have to bring them together.
Yeah, and
you might have been successful in Superior Court.
Yes.
The legal arguments are interesting, and those issues are interesting, but in the end, what we're talking about too is the fact that here's an individual who doesn't understand any of this.
Right.
And he's just facing the loss of his identity and his life, right?
Yeah.
So...
But again, there's limits as to what we can do as counsel to try and get the person in the right frame of mind.
No, but it's important for the public to understand because I hear them. I'm going to go on a bit of a rant right now. I hear
You go, D.
I hear these advocates say all the time that, you know, when a guy kills himself, it's because he's guilty, and there's very few false allegations. The reality is, false allegations happen all the time, and people kill themselves.
Yeah.
And this story is so important because it's important for people to understand the seriousness. And we've heard things like with the 𝐄𝐍𝐉𝐻𝐒 case, Lucy 𝐇𝐎, who named herself in public, said, oh, well, him going to jail would just be like a timeout.
Yeah.
It's not a timeout. These are serious allegations that cause people to kill themselves.
Yeah, but we've also had the Supreme Court of Canada tell us in a certain judgment that false allegations are rare.
Right. But what does rare mean, right? It doesn't mean it doesn't exist.
Rare is a misnomer.
Right.
And it's intended to mean it's significantly infrequent.
Right.
And that's just not true. And again, like we say over and over, we're not saying that women are not victimized. There are legitimate sexual assault complaints, 100%. But there are, on the flip side, there are plenty of false allegations as well.
Right.
To deny that is an injustice which then doesn't serve to protect people who are in your client's position.
And to deny it, right, doesn't mean that the police should just look at every single allegation and assume it's true, right? I
Which
think
they do.
Right. There should that's
Their training.
right. And then they assume
I don't know if it's so much their training as much as it is the policies that are in place. Because again, I can tell you that
I know it's their training.
there are other police officers who would very much like to investigate.
I know, but I also get contacted by police officers who don't want to lay charges, and if they don't, they're told they have to. So
Yeah, but that's the policy. So there, you can be trained in a certain way, and I understand that. But the policy directives is where I significantly draw the liability. Those policy directives come from government. They flow down to the investigative agencies. Those policies
and what's that policy?
are mandatory.
That policy we've heard from Supreme Court. We must do better, which means we must get more convictions. 100%. That is the policy.
Yeah. So it's
At the cost of what? People's lives.
look. It's fine to investigate offenses, but I think what we have to talk about is
I'm doing my little Zen thing.
they have to investigate, and they can't start from a presumption of
right
guilt.
And sometimes that investigation can be like, does it pass the smell test? Right?
There's nothing better than that.
Yeah.
You know, like
Yeah.
we all
I gotta
know,
say,
right?
let's
Yeah.
do better. Let's care about everybody's lives, not just women's. Let's
I
care
hate
about
that
men's.
expression.
Let's care
I
about.
hate the expression,
Let's care
let's
about
do
men's
better.
lives too.
Let's start changing the narrative about how we look at this type of offense versus any other offense. They deserve unbiased, objective investigations.
Absolutely.
Anything else you'd like to say in closing?
No, I think that covers it. Thank you for having me on. And I very much
come back.
appreciate it.
Happy to have you.
I'd go on another rant right now, but
No, we'll
save it
spare
for another
them.
day.
So if you liked what we were talking about, again, please like, share, subscribe.
Comment.
And speaking about comment, we got some more comments in about other areas you'd like us to explore. So keep sending them in. It's very helpful for us to inform what you want to hear about. So thank you very much and have a good night.